Thank
How
you. Good morning. Good morning, everybody. And thanks for that wonderful introduction, Shannon. I'll try not to be so intimidating in the future or this morning. It was wonderful to get the invitation from Shannon to participate in this tremendous event. I'm only sorry I can't be there in person. I'm actually in Washington, D.C., where I'm participating in a hearing at the Inter-American Commission on Human Rights concerning the Maya people of Belize and their land rights, their claim to their traditional lands and resources. Um, uh, Again, it's truly a pleasure to be with you. I want to acknowledge the Association of American Indian Affairs for putting together this wonderful event and thank the association for inviting me to participate. And also want to acknowledge the citizen Potawatomi Nation, which is co-sponsoring the event, as I understand, and also on whose territory this event is being held. What I want to do, as Shannon indicated I would, is to give a pretty high-level overview of the international human rights system as it relates specifically to Indigenous peoples, and talk a bit about how these international standards and mechanisms may support Indigenous repatriation efforts. Okay, there we go. Can you see the words at the top of the screen? I can't quite. Can someone just give me a nod? Yeah, okay, I think so. All right, so first of all, where did these standards specifically having to do with Indigenous peoples come from? That is, these standards at the international level. Well, where there's what we can describe as an Indigenous rights movement that involves Indigenous peoples from around the world coming together and appealing to the formal institutions of the international system, in particular the United Nations, and before that the League of Nations, which is the predecessor to the United Nations. Chief Deskahey of the Cayuga Nation, of the Haudenosaunee League, pioneered efforts in the 1920s to bring concerns of Indigenous peoples to the international system. He went to the League of Nations in Geneva to assert the interests and claims of his people to self-governance against the efforts of the Canadian government to suppress the self-governance of the Cayuga and the Haudenosaunee more generally. He was received cordially and perhaps with a good bit of curiosity, but his efforts were generally not successful because the international system as it then existed only accepted the participation of recognized nation states. And of course, it was those very nation states, such as Canada and the United States, that decided which peoples or nations qualified as fully independent nation states capable of participating within the international system. And so while as I said, he was received with some courtesy and perhaps curiosity, his efforts at that moment were not generally successful. But those efforts did inspire later efforts on the part of Indigenous peoples, initially from North America, Canada, and the United States, but also from South America, and then eventually from other parts of the world, at the United Nations. And a catalyst, a turning point, was at the 1997 conference on discrimination against Indigenous populations in the Americas that was held at the United Nations offices in Geneva. And here, the Indigenous peoples did have a platform. The United Nations did provide a platform for Indigenous peoples to raise their concerns. Within the United Nations, human rights framework, which had been established, or human rights system, which had been established in the aftermath of World War II. The United Nations was created in part out of concern for human rights and fundamental freedoms, not just the concerns of independent states. And of course, that has a lot to do with what was happening leading up to and during World War II, the human suffering that was occurring. And so the United Nations was created in part to address human rights and fundamental freedoms of everybody. And it was within this basis of human rights concern that indigenous peoples were able to gain a significant foothold within the United Nations to press their concerns. And this was significantly beginning at the 1997 Conference on Discrimination against Indigenous Populations in the Americas. And then from the 1980s onward, we see in response to indigenous peoples' concerns, expressions of concerns, we see the establishment of formal international institutional mechanisms focused specifically on indigenous peoples' concerns, beginning with the United Nations Working Group on Indigenous Populations. And I believe Shannon attended the meetings of that working group. And part of the work of this UN mechanism was to specifically develop international standards upholding indigenous peoples' rights. And this working group also provided a forum for indigenous peoples to come at least on an annual basis to coordinate with each other, share experiences, and present their concerns and aspirations to the world community at a formal institution of the United Nations. Now, I don't want to paint too rosy a picture of the UN system as it was capable of responding to indigenous people's concerns. There were a lot of limitations, of course. Yeah, states or nation states are the members of the United Nations, and ultimately they call the shots. So there was some pushback during this process on the part of a number of states, including at some points the United States. But it was the power of indigenous people's stories and the values that indigenous peoples were expressing and putting forward on the world stage on the basis of human rights concerns that really catapulted or moved the agenda forward for indigenous peoples. Such that in 2007, and of course this is after a couple of decades of dialogue and advocacy, the United Nations General Assembly adopted the Declaration on the Rights of Indigenous Peoples. Now, here you see a picture taken by my first generation iPhone at the moment that the vote was taken on the declaration. And you see listed up there on the board the vote tally with 143 UN member states voting in favor of the declaration, 11 abstaining, and only 4 voting against it. And unfortunately, the United States was among those 4, along with New Zealand, Australia, and Canada. Happily, each of those 4, including the United States, in the years subsequent, immediate or pretty much soon after the adoption, the declaration, each of those states, including the United States, reversed positions one by one, so that in December of 2010, at a meeting of tribal leaders at the White House, then President Obama announced the United States position in support of the Declaration on the Rights of Indigenous Peoples. And that has been the official U.S. position since then. No subsequent U.S. president has reversed that position of United States support for the Declaration on the Rights of Indigenous Peoples. So, with the overwhelming vote in favor of the declaration and the fact that each of the 4 opposing states eventually reversed positions, we can say that the declaration genuinely does have the support of the world community. Let me just mention what I see as some of the key characteristics of this human rights instrument, the Declaration on the Rights of Indigenous Peoples. First of all, it is a human rights instrument. It is based on fundamental human rights that in one way or another apply to all segments of humanity. It contextualizes those human rights in the specific context of indigenous peoples, as I'll elaborate upon in a minute. In particular, the rights of equality or non-discrimination and self-determination, these rights being rights applicable generally, but are contextualized by the declaration with regard to indigenous peoples' realities and aspirations. It affirms collective rights, not just individual rights. In general, the human rights that are affirmed within the United Nations instruments and various multilateral treaties and declarations are the rights of individuals. And we see this in the first human rights instruments, the Universal Declaration of Human Rights, which was adopted by the UN in 1948. But Indigenous peoples made the case that their human rights have meaning in a collective context. The right to language, for example, only makes sense as a collective right, as a right of the people of the indigenous nation itself. Other rights, such as rights to religion, the rights to sacred sites, rights over sacred and cultural items. These are rights that are enjoyed and asserted only or primarily in a collective context, that is not just on an individual basis, but as rights pertaining to the indigenous people or the indigenous nation as such. And with the affirmation of collective rights, we see a new model that is advanced, a new model of political organization of the state itself. Many of you will recall the model that was of U.S. state organization that was advanced in the middle part of the last century, which was one of assimilation. The idea being that everybody should be, quote, American, should, speak English, take on the attributes of the dominant so-called American culture, whatever that is. But the Declaration represents the idea that countries, nation states, can be multicultural in character. They don't have to be just one culture, or that the dominant culture isn't the one that has to prevail at the expense of the others. And so the model of state or nation organization or national organization that the Declaration presents or advances is one of a multicultural state, a state in which indigenous peoples' cultures flourish, not just survive, but are able to flourish within the overall, alongside other cultures within the overall context of the nation state. Thirdly, the Declaration can be seen as an instrument of reparations and reconciliation. The Declaration is premised on acknowledgement of the oppression that indigenous peoples have experienced in the past, the taking of their lands, the suppression of cultures, the taking of sacred items. All these facts, all this history is acknowledged in the preamble to the Declaration, and hence we can see the Declaration premised on this understanding. So a purpose of the Declaration is to roll back that oppression, to establish the conditions in which indigenous peoples are able to exercise their rights on the basis of equality with all others. So it calls upon the nation state to take action to repair this oppression, to repair these impediments to the exercise of their rights, and hence the Declaration can be seen as an instrument of reparations and reconciliation. And like I said, it calls for affirmative measures. It's not just a statement of rights of indigenous peoples. The Declaration, in various of its articles, most of them, specifies that states, that is the nation state, are to take affirmative measures through their legislation, through executive action, and through their courts to uphold the rights that are expressed in the Declaration. And then finally, the Declaration can be seen as having a very high degree of legitimacy because it is grounded not just in an affirmative vote by the members of the UN within the General Assembly, but in the indigenous rights movement itself. Indigenous peoples advocates were actually involved in the drafting of the Declaration. Their proposals made their way substantially into the Declaration. And so the Declaration can be seen as resting on a significant level of consensus, not just among states, but with indigenous peoples as well. This really is unique among UN human rights instruments in that regard, in the sense that not just states were substantially involved, that is nation states, in the development of the instrument. In this case, the subjects of the instrument, in this case, the Declaration of the Rights of Indigenous Peoples themselves were substantially involved in the development of the instrument. And so we can say that the Declaration has a high degree of legitimacy because it rests on that consensus, a significant level of consensus among both states and Indigenous peoples themselves from across the world. Now, what is the content of the Declaration? What does it say generally? Well, here are the basic principles that are advanced in the Declaration and the rights that are affirmed or associated with these principles. Principle equality. So the Declaration affirms that Indigenous peoples and individuals are equal to all other peoples and individuals. And that's a foundational premise of the principle of the Declaration. And then Article 3 affirms specifically that Indigenous peoples have the right to self-determination. By virtue of that right, they determine their own political status and determine their own economic, social, and cultural development. This is a very important part of the Declaration because it affirms that Indigenous peoples, like other peoples of the world, do have this fundamental right of self-determination. It includes various provisions affirming Indigenous peoples' cultural rights, including, as I'm going to get into a little bit more in a second, Indigenous peoples' interest in cultural items and ancestral remains that are important to the cultural integrity of Indigenous peoples. It has a number of provisions affirming Indigenous peoples' rights over traditional lands and resources. Also affirms the right of Indigenous peoples to a healthy environment. And then a number of provisions regarding what we refer to as social and economic rights, that is, rights to health, education, and development, but rights that to health, education, development in a socially appropriate context. And what we see by this affirmation of rights, as I indicated earlier, is that the Declaration doesn't really establish new human rights. By definition, human rights apply to everybody. What it does is builds upon generally applicable fundamental human rights and contextualizes them for Indigenous peoples and in regard to their particular realities, and affirms them in a collective sense, as I indicated earlier. So this is essentially the basic, in a very summary fashion, the content of the Declaration. And as I said, the Declaration does refer to ceremonial objects and cultural items in the following sense. It's Article 12, and I'll read that here. Indigenous peoples have the right to manifest, practice, and develop and teach their spiritual, religious tradition and customs and ceremonies, and practice their customs. And they have the right to maintain, protect, and have access and privacy to their religious and cultural sites, and the right to use and control their ceremonial objects, and the right to the repatriation of their human remains. And then paragraph 2, and I'll just read Article 12, and I'll just read the first part. It requires that states shall seek to enable the access and or repatriation of ceremonial objects and human remains in their possession by fair, transparent, effective mechanisms. And so we see an explicit reference by the Declaration to the right of Indigenous peoples to their spiritual religious tradition and the right to use and control the ceremonial objects and the right to repatriation. And a mandate for states to enable access and to enable repatriation of these ceremonial objects. Article 12 then speaks very directly to the subject of this conference. And here, I think you can see the hand of Indigenous peoples who were involved in the process. It wasn't states who were raising this issue in the development of the Declaration. It was Indigenous peoples by telling their stories about the deprivations of their religious and spiritual traditions, or the impediments to the exercise of their religions and their control over ceremonial objects. And so because of Indigenous peoples' advocacy, Article 12 made its way, among other articles and provisions of the Declaration, made their way into the Declaration. Now, this is just one of 46 articles of the Declaration, but I wanted to highlight this one because of our specific concern with repatriation today. Now, the question often comes up. Well, what is the status of the declaration? What does it mean, and how does it relate to what's happening here at home, and what practical effect can it have? Well, first of all, we can just note that the declaration is a resolution of the General Assembly of the United Nations, and it comes under the General Assembly, and it was adopted under the General Assembly's authority to make recommendations of concern to UN member states, including on matters of human rights. So, in a technical sense, it is not an instrument that is like a treaty that establishes by its own right legally binding commitments. But it is an important instrument because it comes out of the General Assembly, which is made up of all the UN member states. And at the very least, it represents a policy and a moral commitment by the nation states, by the state members of the international community, to the rights expressed in the Declaration. So when the United States expressed its support for the Declaration, expressed at least a moral and policy moral commitment to the rights in the Declaration. But the question arises. The question arises: how, if at all, does the Declaration represent or reflect legal obligations? And this is, the lawyers among you will have that in your mind. A question that is always there. Well, okay, we know it's this policy statement, and it expresses moral commitment, but does it represent obligations of a legal character? Well, I and many others, and I would say most others who have discussed this question, think that the Declaration does have legal implications and does have a legal character. First of all, the Declaration informs the general human rights obligations of states, that is, members of the United Nations. Every country that becomes a member of the United Nations, they do so by adopting the UN Charter, and the UN Charter obligates all countries to promote human rights. And so the Declaration can be seen as connected with this legal obligation that the state members of the UN have to promote and respect human rights. So it informs this general legal obligation of states, including the United States, to promote human rights as members of the United Nations. Secondly, and this is it gets into the technicalities of international law, but we can say, and several scholars, and not just me, have asserted, and some courts in a number of different countries have asserted that the Declaration helps to build, and to some extent already reflects what we call customary international law. Customary international law, as the name suggests, is that part of international law. It's not based on written instruments, but necessarily or exclusively, but based on custom understandings among the countries of the world, along with a sense that they're obligated to follow the rules that are derived from that custom. And so the Declaration can be seen as contributing to international custom, and hence customary international law that is binding on countries in that sense. Then finally, it contributes to the definition of human rights norms that are already found in multilateral treaties to which the countries, including the United States, is a party. So there are already various human rights instruments that include multilateral treaties that are, by their very nature, are legally binding. These multilateral treaties include principles and norms that are elaborated upon in the Declaration, and hence the Declaration contributes to the definition of these human rights norms that are in these multilateral treaties that are binding upon countries, including the United States, in regard to the treaties that it is a party to. And so I'll give you the two most prominent treaties that the United States is a party to that illustrate what I'm saying here. First of all, the International Covenant on Civil and Political Rights, or as it's often referred to, the ICCPR, affirms a number of civil and political rights of people, and by becoming a party to this treaty, like the United States has, the countries, including the United States, are bound to uphold these rights. And two articles are of particular relevance, and Article 1, which upholds the right of all peoples to self-determination. And what we see the Declaration doing is basically borrowing from this language and specifying that this right of all peoples to self-determination that we find in the covenant applies also to indigenous peoples. So there's an example of a very important example of the Declaration, building upon the rights that are already in a treaty and that to which countries are bound. Another article that's important is Article 27, which affirms the rights of minorities to enjoy their own culture, profess and practice their own religion, and to use their own language. And of course, the Declaration builds upon this right in the specific context of indigenous peoples, as I've already indicated. Now, of course, it's not the case that indigenous peoples are mere minorities, and the minorities category encompasses all types of groups. Nonetheless, this right of minorities has been interpreted as having specific, or this Article 27 has been interpreted as having as indeed having specific meaning for indigenous peoples. And this interpretation has come from the UN Human Rights Committee. The UN Human Rights Committee is itself established by this treaty. The treaty, in addition to stating a number of rights, establishes the Human Rights Committee to monitor and promote compliance with these rights. And part of the committee's work is to issue interpretive guidelines, as well as to examine particular state conduct under the treaty. And the Human Rights Committee has interpreted Articles 1 and 2, these two articles, specifically in the context of indigenous peoples, and affirmed that these articles broadly protect indigenous peoples' rights, to the extent that it sees Article 27 as protecting all aspects of indigenous peoples' culture, including those aspects related to lands and resources, seeing lands and resources important to the development and exercise of indigenous peoples, and also culturally significant or spiritually significant items fall within the purview of Article 27 because of the significance of such items, those to the cultures of indigenous peoples. And so Article 27 is seen as broadly protecting all aspects of indigenous peoples' cultures as defined by their own cultural patterns. And another treaty, and of course, and maybe I failed to mention it, but I want to emphasize that the United States is a party to the International Covenant on Civil and Political Rights. This is a treaty to which the United States is bound and that establishes legal obligations for the United States. Another treaty is the International Covenant on the Elimination of all forms of racial discrimination. Another human rights treaty to which the United States is a party, and that is hence binding on the United States. As the name of the convention suggests, it promotes the non-discrimination, particularly based on race. Now, like the human rights, like the ICCPR, the other treaty we just talked about, this treaty, the Convention on the Elimination of Racial Discrimination, also establishes a committee to monitor and promote compliance with the treaty. And this committee, is called the Committee on the Elimination of Racial Discrimination, or as is often referred to by its acronym, CERD. And as I mentioned, it is also established by the treaty, the relevant treaty, in this case, the Convention Against Racial Discrimination. And this committee has interpreted the non-discrimination standard that's embedded in the treaty very broadly in favor of indigenous peoples. It issued an interpretive comment in 1994, as early as 1994, even well before the Declaration, stating that indigenous peoples, observing that indigenous peoples have suffered historically racial discrimination by the taking of their lands, the suppression of cultures, identifying those events, that oppression, historical oppression of indigenous peoples, as racially discriminatory, and identifying any continuation of that kind of oppression of indigenous people's cultures or self-determination as, in fact, racial discrimination. The taking of their lands, the committee also identified as based on as racially discriminatory. And so the committee then called upon states in order to restore indigenous peoples' rights over lands and to their culture as a matter of obligation under this convention. And so we see this convention having real relevance to indigenous peoples, and also as elaborating upon, as being a basis for the standard of non-discrimination or equality we see in the Declaration on the Rights of Indigenous Peoples. I should mention that both CERD and the Human Rights Committee, the other committee, now rely specifically on the Declaration. They cite the Declaration as they interpret the relevant treaties. So we see an interconnection between the Declaration on the Rights of Indigenous Peoples and these human rights treaties of general applicability. So another instrument is the American Declaration on the Rights of Indigenous Peoples that I want to mention just briefly. Now, the UN Declaration on the Rights of Indigenous Peoples was adopted by the United Nations, and at the same time that the process was moving forward for the development of the UN Declaration, there was a process towards development of a declaration on the rights of indigenous peoples at the regional level in the Western Hemisphere through the Organization of American States, which is the intergovernmental organization that the United States and Canada and other countries in the Western Hemisphere are parties to. That organization, the OAS, Organization of American States, is similarly founded upon general principles of peace and human rights and cooperation. And it includes human rights mechanisms, and those mechanisms developed in consultation and with the cooperation of indigenous peoples an American Declaration on the Rights of Indigenous Peoples, and it was adopted in 2016. Now, it reinforces the standards in the UN Declaration and the interpretations of relevant human rights treaties. And we see the various institutions of the OAS using the American Declaration on the Rights of Indigenous Peoples to interpret states' obligations, the obligations of the US and other members of that organization under the OAS Charter and other treaties. So it reinforces the standards of the Declaration and also the interpretation of relevant human rights treaties. And then it also includes specific reference to repatriation and the need for restitution of the taking of indigenous peoples of their, as stated in Article 13.2, calls for restitution for the taking of indigenous peoples, quote, cultural, intellectual, religious, and spiritual property that was taken without their consent. Again, that is just one of several or many provisions of the OAS Declaration, but it's I am highlighting it here because of our focus on repatriation today. Now, how can these declarations and treaties have any application at the domestic level? What significance can they have here at home, of course? And this relates to the question of their legal significance. Now, there's a lot of complexities in trying to answer this question of what the application they can have, and this is something in my international law and human rights classes and indigenous rights classes I spend a few days on. So I'm not really just able to do justice to an answer to that question here, but let me just highlight a few things, try to highlight just a couple of things. One, international standards that should at least guide decision by the government, both including the executive, the legislative, and judicial branches in their decision making. Now, this sounds like it's maybe a bit utopian, but in fact, we do see cases by the US Supreme Court and other federal courts and state courts using international standards, international human rights standards to interpret the Constitution or domestic legislation or prior judicial doctrine concerning indigenous peoples. This is something that the courts have done, using international standards to interpret domestic legislation. So at least theoretically, we could see the courts using Article 12 or Article 13, Article 12 of the UN Declaration or Article 13 of the American Declaration to interpret NAGPRA or other relevant legislation regarding repatriation. And even if courts aren't doing it, the different executive agencies or even Congress could look to these standards to act. And so we see this happening all over the world, and there's no reason why it couldn't happen here in the United States. In fact, the treaty obligations do establish legal obligations for the United States, and hence it is good practice for the executive to act in accordance with those legal obligations that the United States has. So basically, the bottom line, tribes, indigenous nations can use these international standards, those found in the Declaration and in these human rights treaties, as advocacy tools. They can use these standards as advocacy tools when they go to executive agencies, to the White House even, to Congress, and their lawyers can use it, can use these standards in advocating before courts. It's kind of a technical thing to do, but it is possible. And in other areas of human rights law and domestic law, we've seen that done, the use of international standards in judicial proceedings. So there's a lot more to be said about this, perhaps, but anyway, I just wanted to highlight some of how we can see these standards applying domestically here at home. Now, apart that there are mechanisms, international mechanisms to advance indigenous people's rights. Of course, if we could rely on the domestic actors, the local actors to always uphold the rights, we wouldn't need these international mechanisms. But across the globe, very often, the governments at the local or domestic level aren't upholding the rights that they were obligated to, or and they committed to uphold. And so we do have these international mechanisms that promote their compliance, and indigenous peoples and others can go to these mechanisms to in efforts to promote their interests and claims and gain some kind of redress. First of all, there are the procedures within the Organization of American States. So I mentioned that the Organization of American States has developed the American Declaration on the Rights of Indigenous Peoples, and there are various mechanisms within the OAS, particularly those associated with the Inter-American Commission on Human Rights, which is part of the OAS. And like I said, I'm here in Washington today because I have a hearing with the Inter-American Commission. I'm here with leaders from Maya communities in Belize who have submitted a petition, and they submitted it some time ago actually, to the Inter-American Commission because Belize was failing to recognize and protect their rights. Now, the commission gave a positive decision. They agreed that Belize is obligated to secure their land rights and rights over resources, and can't just grant logging or oil development concessions on their lands without their consent. And so this hearing is about how to assist Belize, is about how Belize can move forward with implementing that decision. So that's just an example of the procedures that exist within the Organization of American States to promote the application of indigenous people's rights. Now, there's also monitoring procedures of the UN treaty bodies. Now, I mentioned Human Rights Committee and CERD. I mentioned how those committees have interpreted the relevant treaties, the ICCPR and the Convention Against Racial Discrimination. These treaty bodies also specifically monitor countries. So every so often, every 2, 3, 4 years, the United States has to go to the Human Rights Committee and to CERD and submit reports about how it's complying or what difficulties it's having applying with those treaties. And those committees offer the opportunity for others besides the country, the state or the government. It offers the opportunity for indigenous peoples in particular to offer their information And the committee will then examine carefully the country's behavior based on that information provided by indigenous peoples. And there have often been very interesting dialogues and pressure brought to bear by the committees on countries to move to more faithfully implement the standards in those treaties. Then there's a procedure connected with the UN Human Rights Council. The Human Rights Council is the major international organization within the UN system that promotes human rights, and it has what's called a Universal Periodic Review. This is a procedure by which it reviews every country every 4.5 years. Every 4.5 years, every country has to go before the Human Rights Council. And the council, again, welcomes information by indigenous peoples and others, and uses that information to question the country and pressure the country in many instances when the country is not living up to its human rights obligations. And then there are a number of mechanisms specific to indigenous peoples. These have to do specifically with indigenous peoples. Now, I mentioned these other three because they, one, are important ones, but they apply generally with regard to human rights. They do offer the opportunity for indigenous peoples to access them, but there are other mechanisms, and I'm going to talk about those now, that are specific to indigenous peoples. One is the Permanent Forum on Indigenous Issues. It's a UN institution, 16-member expert group that advises the UN system and allows for indigenous peoples to make statements and present their concerns. It can't really resolve problems, but it can raise them, help to raise them to countries. Another mechanism is the Special Rapporteur on the Rights of Indigenous Peoples. This is an expert that's appointed by the Human Rights Council to address the specific concerns of indigenous peoples worldwide. Now, Shannon mentioned that I held this position. I held it for 6 years, 2 consecutive terms. And in that position, I received information about and addressed situations about indigenous people's human rights across the globe. And on several occasions, that information had to do with repatriation concerns. And I would engage the countries concerned about the indigenous people's concerns in that regard. And, sometimes almost always the states would listen, and then sometimes they would actually take action in response to my recommendations. And today, the Special Rapporteur continues this. The current Special Rapporteur, of course, continues this work. And then there's the expert mechanism on the rights of indigenous peoples. This is a 7-member group that is established, and this is again a UN mechanism that is established to conduct studies, but also to provide advice on the implementation of the UN Declaration on the Rights of Indigenous Peoples. Now, this expert mechanism was established the same year that the UN Declaration was adopted, and the idea was that it would have a significant role in advancing implementation of the Declaration. And there's in a very important recent case that the expert mechanism was involved in that had to do with a sacred item that had been taken by an indigenous peoples. This was a ceremonial item that a deer's head, essentially, that was held by a Swedish museum of ethnology in Stockholm, that was part of the Swedish National Museum system. And with the expert mechanism's intervention, this item was eventually returned to the Yaqui people of Mexico. Like I said, this return was facilitated by the expert mechanism on the rights of indigenous peoples. The museum said, we validly acquired this item. We didn't acquire it illegally. At the time we acquired it back in the early 20th century. We weren't party to the relevant UNESCO treaty or anything, and so it was legal. But of course, the expert mechanism was applying the standard of the Declaration on the Rights of Indigenous Peoples, by which states are to facilitate the return of sacred items to indigenous peoples that have been taken without their consent. Eventually, the expert mechanism was able to facilitate an agreement between Sweden and Mexico for the return of this item to Mexico, and Mexico then agreed to return the item to the Yaqui people where it is now, happily. And this happened within the last couple of years. So what we see happening is the implementation of Article 12 of the UN Indigenous Declaration, which calls upon states to repatriate cultural items, as you remember, in conjunction with Article 15 of the 1970 UNESCO Convention on cultural property. The name of the convention is here, and you may be familiar with it at this point, or I think there's going to be further discussion on it later. It's the UNESCO Convention that states, countries have signed on to, that prohibits illicit import, export, and transfer of ownership of cultural property and provides for mechanisms for their repatriation. The problem is, it only applies as of the time the convention became enforced in 1970, and not retroactively. And so the prohibitions of the convention didn't apply to the taking of the Yaqui people's sacred item back in the early 20th century. However, Article 15 of the UNESCO Convention allows for special agreements for restitution of cultural property that was taken before the convention was in force. And so the convention basically says that, okay, it only applies prospectively, but in the interest of equity and fairness, states can enter into agreements even if the property to repatriation, even if the property was taken before. And here we see the expert mechanism facilitating and advancing such an agreement based on the requirements of the UN Indigenous Declaration, UN Declaration of the Rights of Indigenous Peoples, particularly Article 12. Now, more recently, we've seen just a couple of weeks ago, last month, the UN Human Rights Council called upon a new mechanism to facilitate indigenous peoples, the repatriation of indigenous peoples, sacred and spiritual items, building upon this example of the expert mechanism. And then also to keep in mind is the Intergovernmental Committee of the UNESCO that promotes agreements for repatriation, even if they're outside of the prohibitions of the UNESCO Convention, because the taking of the items took place before 1970. So you can say there's a lot going on, and there are some important developments and possibilities. So this information is not to suggest, I give you this information not to suggest that everything is resolved at the international level. You have ready-made remedies, but there is a basis for advocacy. There is a basis for efforts that could be successful using these mechanisms to achieve the repatriation of items that have deep cultural significance or spiritual significance to indigenous peoples. So with that, I thank you very much for your attention, and I'm happy to answer any questions or hear any comments. Thanks a lot.
Hello. Oh, hi. Kulamasi, Asko Wikwasan. My name is Keisha Talking Waters. I'm Rempo Lenape Muncie in Shinnecock. Yeah, I'm having my fangirl moment right now. So hard. You single-handedly are the only reason that I decided to go to the University for Peace in Costa Rica, the United Nations mandated university, and study international relations. I was the only openly indigenous person in my department, in my program, and I think being just a hard-ass Eastern woman, that resulted in a scholarship for all indigenous folks with a 30% discount in indigenous youth who want to study international law. And so I say that for those in the room who want to go home and tell your children and work on that. But I want to start with my own version of the words that come before all else that you did, essentially. As you spoke, I just jotted down some things, but I also want to thank you because you are the only human that has spoken about my nation as a state-recognized people with respect and with quality, and looked through the lateral violence that exists and looked through the ecocide and the eugenics study, as we were the first people of Goddard's eugenics study. So with that being said, you know, the affirmation of collective rights, the structure of state and fed recognition then tarnishes that in my mind in so many ways. And I think about the ICCPR and the role of state recognition. I would love to hear more of your comments on how that does apply at an international level and in relation to the ongoing domestic state, because arguably I don't see a genociding country continuing to practice federal recognition in this state. So yeah, I'm also curious in terms of the obsession or the need still with colonial institutions and tools. We don't have an indigenous court at the international level. We don't have an environmental court at the international level. We go to Den Haag. You know what I mean? There's limited locations, there's limited things. So I'm curious how that functions when we also, at the end of the day, have nations that don't even have their own schools for their youth. They still go to public schools. So that sovereignty, that self-determination, what do we do so we make sure we don't need to repatriate my body, my children's body one day? Up until now, it has been customary law to commit genocide. So we're also looking at an epistemological shift that requires reconciliation of self and of history that, as you said, there's a lack of retroactivity. But we're dealing with people who are now radioactive. Why is it that our treaties and our history is apparently too old for the United Nations and apparently too old to be valued or respected? And you know, one thing that I really struggled with, and I don't know if you know Mihir Kanad, but he was my mentor at UPeace, and coming out of India and kind of having that cousins and colonization conversation, the UN is really stuck in this naming and shaming game. It's not to say or to diminish what legal efforts are starting to be applied with UNDRIP, but I'm curious, for indigenous purposes, how do we go deeper with that? How do you see, maybe in your personal but also professional realms, that ancient conflict negotiation methods that aren't included in NAGPRA? We need deep conflict negotiations. We need longhouses again. We need opportunities to really come together and have conversations that are beyond the political and that are beyond these realms. And yeah, I think also, given this being my also academic and personal interest, the indigenous issues that are currently being covered at the UN are through the ECOSOC chamber, right, and through the environmental lens. We have, I think, still very few voices, you know, to follow Danae Weaver women realities and those connections. I don't see them all at the UN, and you know, coming out of the SDG Action Week and somebody who's a part of the UN Envoy for Youth, that's something that is struggling. And you know, thinking about UNDRIP and Asian and African states that really struggled with concepts that would have led to land back because of their ongoing colonial hold. Their youth are struggling with similar issues that state recognition that we too struggle with, let alone the role of Palestine, the role of Kosovo, Kurdistan, other nations that have these underlying and deep-seated similarities. I was speaking earlier with some people about Iceland being one of the few EU countries that claims they have no indigenous people, but they're an Arctic state. Their land is indigenous, their animals are indigenous, and they too have participated in taking things from people. How do we hold them accountable legally, culturally, and what role do institutions really play in all that? And so I know I said a lot here, and I'm so sorry. I also thought you would physically be here in person, so I have gifts for you that I will give to Shannon in hopes that they will find you. But thank you for everything you do, and I really hope Piscataway lands treat you well.
Thank you for those comments. Let me just say that I pretty much agree with everything you've said. There are enormous limitations in this system, and what I've tried to do is show the movement within the UN system and the power of indigenous peoples' discourse when they have been given a hearing. And there's still a long way to go, of course, and the impediments that you mentioned are there, including the impediments to real and adequate participation. But if we look where things have gone since the days of Descahe, it's a long way. And there are discussions now within the UN promoted by indigenous peoples, the discussions promoted by them about how to enhance indigenous participation and provide a genuine place for indigenous peoples within these international forums. The way I like to see it is, you know, there are the colonial structures that have been put in place and that are well established within the international system and within the domestic system. You know, we have the same thing domestically. Our courts, sort of the debate, the doctrines that we see within what we call federal Indian law. These are colonially rooted, but then there's a movement that can take place within the discourse of human rights that pushes against that, and it depends on all of us, on indigenous peoples, on those caring about human rights, to push that movement. So I'm confident that that it'll continue to move forward, and that push will continue to happen.
Paul, before we begin, do you mind if I, okay. So we have a question on the Zoom participants that are putting theirs in, and it's from Joyce Fry. There seems to be a fine and indefinable line between aspirational mechanisms and enforceable ones. How can that gap be reconciled, if at all? Thank you.
Right. Well, you know, even when we go to court here in the United States, it's aspirational. We're hoping for an outcome, that we're hoping for compliance with whatever the courts say, and that often is slow or even doesn't happen. You recall, you know, way back in the 19th century, Andrew Jackson said, John Marshall has made a decision in favor of the Cherokee, let him enforce it. And that decision wasn't. So we have, you know, that is always a challenge, you know, to move from actual enforcement, implementation of these standards, from the aspiration that the standards represent. But again, I want to emphasize that it's understanding, you know, the specific tools and strategies that can be used, and then using them. The UN Declaration will not have it make a difference unless people use it. You know, those in authority will not know about it unless it is used. And countries and those in authority are reminded that they have an obligation to move forward with it. The courts will not use these international standards. I'm talking about the domestic courts, unless advocates actually use them, as they do in other areas of human rights or other areas of domestic law. Yes, it's a challenge, but in my view, the answer to that challenge is not to recoil from it, but to take it head on.
I'm Dr. Paul Edward Montgomery Ramirez. I'm a Montemoseño Chorotega from what is currently Nicaragua. My question is, I wanted to ask a little bit about how you to discuss a little bit more about stumbling blocks that these mechanisms and these resolutions kind of place for indigenous people. Just kind of as an example, hello? Oh, still there. As an example, the government of my country, well, they have stolen our elders who are still alive and replaced them with their own individuals, and have sent state-approved members to the UN to discuss indigenous issues that then do not represent the spirit of our actual, you know, indigenous governance, and in kind of less of a severe way, less of a severe instance of that. I was working with the Indigenous Fellow for WIPO, for Indigenous Indigenous intellectual property, and as our community, the Chorotega are divided by state borders between Nicaragua and Costa Rica. So one of the issues that we have is, as our cultural elements are being used by both the Nicaraguan and Costa Rican government, and in an effort to assert our sovereignty over that, there's been the move to try and get that intellectual property, our rights to that. But as it was kind of explained to me, that if the communities in Guanacaste get intellectual property rights over what is considered like Chorotega material, then that kind of makes it so that way the Chorotega in Nicaragua don't have equal access to that then because of the borders that divide that. And it this is still using the within UNDRIP the conversation of sovereignty over that. So the ways in which how the UN operates based on states as opposed to the use of the word nation state, which in itself is a troubling word to use. Just how can we work with those stumbling blocks that seem to be hard baked into the entire concept of the United Nations? Thank you.
Right. Thanks. You know, you've just pointed out other limitations to the system, and that is borders, right? That's a big one. The Declaration does say that states should facilitate cross-border relations among indigenous peoples, and you can transpose that into different areas, including intellectual property regimes. And there has been a good bit of movement on recognition of indigenous interests and rights in intellectual property at the World Intellectual Property Organization. Not sufficient, and again, there's a lot of pushback by different governments, but indigenous advocates are there pushing forward for different mechanisms of recognition of indigenous people's property interests. And also the private sector has responded. We see more and more the private sector, which is often in very many instances appropriate indigenous people's intellectual property designs, art forms, is now starting to respond. And now as for Nicaragua, generally, Nicaragua is a very sad situation. It's a place I'm very familiar with. I've worked with the Mosquito and Mayagna people there over many years, litigated cases on their behalf. And right now, the people of Nicaragua and indigenous peoples, I understand, are under siege. And the Nicaragua, the government has pretty much taken itself out of the discussion of human rights generally. And so it's very hard in a context like that, when the country has said, we're not going to cooperate with the international system or with the human rights mechanisms for these mechanisms to have any real influence. And it's very, very sad. You know, one of my dear friends, Brooklyn Rivera, one of the indigenous leaders, is now jailed, and it's unknown what his condition is now. So I really do feel for that situation, and also feel, honestly, given that friendship I have with him and others in Nicaragua, the helplessness that many do feel in the face of those kinds of actions, and also the futility of many of the mechanisms that I've just described in regard to those specific actions. But that doesn't mean we do nothing. You know, we continue to press, we continue to use whatever means we can to help uplift the voices of those who can't be heard in whatever form and whatever we can, including meetings like this.
Thank you.
Dr. Anaya, this is Frank Edawagishik, and I know we spent quite a bit of time in Bangkok working on participation issues together, and many other places. It's good to see you here. I appreciate your presentation. I think one of the things that is very evident through your presentation is the incremental progress that has been made. That we didn't start out where we are now. We've made little tiny pieces, or sometimes big pieces, coming together to build us to where we are now. And yet we're still far from where we need to be. And I wondered if you might comment about that, where you think we may be going next with these issues. Where are the things that we need to be looking to in the near future in terms of continuing that incremental progress in working on indigenous rights, both for repatriation and for participation of indigenous nations, and all these other factors that we're working with that sort of all come together hand in glove. So I just was interested in getting your comments, and it's good to see you again. Thanks.
Thanks, Frank. It's very good to see you. And I always do enjoy seeing you when we come together in different settings. Yeah, that's a great question. And, as to your observation about the incremental progress, yes, that's absolutely true. And, we look back to, Deskehe or even before that, and the outright exclusion of indigenous peoples from the international arena, from being able to criticize and push states from the outside. That and the progress that it's been made since then is really, really something. Even the adoption of the Declaration on the Rights of Indigenous Peoples. I remember it was just 3 weeks or so before the declaration was adopted, and I was giving a lecture about it. At the same time, I was involved in trying to push its ultimate adoption by the General Assembly, and I was just questioned repeatedly by people in the audience, and who were just bombarding me, saying that I was naive, that this would never happen, that it was impossible that the General Assembly would adopt an instrument like the Declaration on the Rights of Indigenous Peoples. And I shared a lot of the skepticism, but I've learned from so many elders and others that having that aspiration still guide one, even in the face of adversity, is so important. And 3 weeks later, the Declaration was adopted. I really do believe that we're now in a phase when it's so important to develop mechanisms of implementation. How can we see these barriers overcome so that states will actually move forward in implementing these rights that have been affirmed at the global level? What kind of cooperation can there be on the global scale and between indigenous peoples and government? What kind of mechanisms can there be? And that really, in my mind, has to be where the focus is at this stage. And then along with that, and I think a key part of that implementation is participation by indigenous peoples, not just within their countries at important venues, but at the international level. I do think there is a place for indigenous peoples to genuinely participate at the international level. Within the UN and other international institutions, and that I do think that's going to be worked out eventually. The UN Human Rights Council and the General Assembly very recently in resolutions have called for progress on the development of specific mechanisms for indigenous peoples to participate. I was just meeting with folks at Interior yesterday, and they are actually doing what they can to push for that. For greater participation of indigenous peoples at the UN. And I know the State Department is to some extent as well. So it's a long struggle, but I do think that is really it's those two things: implementation, mechanisms for the implementation, and greater means and formal means of participation on the part of indigenous peoples at these international institutions. But thanks for that question, Frank.